let's get straight into the discourse for today. We'll begin with the global commemoration, which is World Intellectual Property Day. We're joined by a legal practitioner, and he's here to do justice to the issue. Never seen him in trad, by the way, let me tell you that. And I had to tell him that, hey, it looks like a difference you came to the studio today. Good morning, Jibonoh.
Yes, good morning, Blessing.
And it's good to see you not in suits, like you're ready to get into court. It's Friday, really.
So he's trying to portray the fact that the weekend is loading.
Yes. I know a lot of people don't believe that lawyers put on traditional wears, but you do put on traditional wears.
All right.
You're proud of the African attire. Glad to have you joined us.
Yes, the pleasure is mine, sir. Yeah.
So today, looking at World Intellectual Property Day, it's a global observance, but we're also going to look at how it connects to Nigeria and what are the issues. First, let's understand what intellectual property is and why this day is significant.
Well, for you to be able to understand, or let me just start by saying this, intellectual property as an area of practice, it's a very broad area of practice. It covers a lot of parameters. And for you to be able to understand and appreciate what intellectual property is that you need to look at these two key words that makes up intellectual property, intellectual and property. So intellectual derived from the word intellect, which has to do with something of the mind, a creative of the mind. Okay, then property means something that belongs to a person. Okay, now putting those two things together, we are talking about your creative mind that actually belongs to you. Okay, now you need to protect it, this your creative, from being infringed by some other persons because it is your work. So it is that's the reason why it is significant that it is being celebrated all over the world, because everybody all over the world have one or two creative minds, and it takes a lot of energy, resources, physical or financial as the case may be, to put up a creative work for you to now be deprived of that by somebody else who does not know about it. So that's the reason why there are laws regulating intellectual creativity. So that's the essence of intellectual property law.
Okay, let's start from the legal perspective. Interestingly, you're a lawyer. So what are the various rights when you talk about intellectual property for someone who owns one? Okay. There are limits to rights, but it's also important to know these various types of rights that are available to someone who owns an intellectual property to an asset. Can you talk about them?
Yes, intellectual property rights is exclusive. When I mean exclusive, means it is peculiar and it is particular to the genuine owner of whatever intellectual creative. Okay? So now, intellectual property can be categorized into various categories. You have trademark, you have copyrights, you have patents, you have industrial designs, you have company name. Now, if you look at all these categories, they can be peculiar to a person being an individual or to a company being an artificial person. Okay, so now when you have this exclusive right, it means that this right belongs to you and nobody else should use it except for you. Or probably if you grant license to it, to some other persons to use. Okay, so it's a peculiar right that means if you are given that right, it belongs to you and nobody else should use it or should infringe on that right. So once you have an intellectual property, it means that you are the only person who can use it and nobody else. And if it is infringed against, you have the right to approach the court, to claim damages or to ask for an injunctive relief. Okay, yes, because provided you can prove to the court that this intellectual creativity belongs to you. So that's it.
All right, the theme for this year's observance is IP, which is intellectual property and the youth shaping the future. And now let's come to Nigeria, where we have majorly a youthful population, and many of them are creatives. How does this theme apply? Are there areas that the intellectual property law of Nigeria has not really looked at, given the kind of creatives that we're having right now that should be looked at on a day like this?
Okay. Like I said, the categories of intellectual properties we have, let's, for example, copyrights, there is an extant law, what I mean, Nigerian law, that regulates, protects copyright as an intellectual property. So, and this law is known as the Copyrights Act. And we have an agency that administers this Copyrights Act, which is the Nigerian Copyrights Commission. So if you have a creative work such as a literary work, you are an author of a literature, books, textbooks, and all. Of course, provided you can prove that you are the owner of that literature work, automatically you are entitled to the protection of copyrights, the protection that affords you as a copywriter, okay? Now, in the area of cinematography, you know, films, motion pictures, if you can prove that you are the producer of this film, of course, automatically you are entitled to the protection of copyrights law, act, as the case may be. So, but the only way that you can prove, of course, you know, being the originator of this creative work, automatically you are entitled to the protection of copyrights. But the only way you can actually prove that you are entitled to this copyrights protection is by registering that creative work. Okay, so that is the reason why it is usually advised that, oh yes, you can be the originator of a literary work or an artistic work, as the case may be, or a musical work, as the case may be. You have to prove by showing that you actually registered this creative work with the Copyrights Commission. Okay, now in the area of trademarks, of course, we have the Trademarks Act 2004, which is the law that regulates trademarks. Of course, you know the things that fall within trademark has to do with company's name, marks, signs. These are the things that comes under trademark. You can decide to register it. So once you register it under the trademark, of course, that is to show that you are the owner of this creative. Then we also have in the area of patent and design, we have the Patent and Designs Act, which also regulates that area. But the only area that has to do with intellectual property, which Nigeria as a country does not have an extant law, is in the area of trade secrets. You know, we've not advanced to that level. What do I mean by trade secrets? What I mean by trade secrets is that the secret behind the production of any job. Okay, you know, let's say production of any engineering job, there are certain secrets that is peculiar to the producer of that engineering job, which requires confidentiality. And if that confidentiality is breached, how do you claim damages or enforce the breach of that trade secret? There is no extant law, like in the area of trademark, like the area of copyright, patent and designs, that is regulated by law. So you see, that area is one area where owners of copyrights or trade secrets don't usually have remedies when such trade secret is infringed. Although I usually advise people, although there is no extant law, you know, protecting trade secrets, okay, but you can try to enter into a contract with the person who you are trying to divulge your trade secret to, a contract of confidentiality, you know, non-compete, non-circumvention. So once you do that, you'll be able to enforce that contract. If there's a breach of it, you claim damages or an injunction, as the case may be, in court, because you have a contract that protects that trade secret. So I used to think, yeah, there's no extant law protecting trade secrets, but you can go into contracts, non-circumvention, non-compete, confidentiality in order to protect your trade secrets. I'd had a situation where a client approached me that he has this innovation that he wants to introduce it to the government. And it was like, how can he protect it from being infringed? Probably if he divulges the secrets and it's being infringed, how does he protect? I said, there is no law, extant law that would protect you if you divulge that secret and decide to use it behind you. But you can just tell them, oh, I want to, firstly, before we go into the discussion of this project or this innovation that I have, I want us to enter into a contract of confidentiality, non-circumvention, non-compete. They won't use it if there is no agreement between the two. And if they sign that, and they now eventually go behind you to use your trade secret, then you can sue them for they've breached your contract of non-confidentiality.
But that's a contract that you can introduce at the point where you divulge certain secrets. What if the other party refuse to sign to it?
Yeah, there is no need for further proceeding with that transaction or discussion, as the case may be. Just take your leave.
All right, let's talk about trademark, and how important it is it is when it comes to business. A lot of people will just assume, okay, I own the right to this logo, I own the right to this intellectual property. But why is it so important to go ahead and register it for or trademark it so that it has that originality? What is the level of weight when it comes to trademarking according to the law?
Okay. Now,
how weighty it is?
Yes, of course. You can be the originator of a sign, a mark, a symbol. When they see this sign, they know this sign is identifiable to this product. I don't want to mention names, okay? But the only way you can prove that when there's an infringement of that trademark, where there's an infringement of that trademark, the only way you can prove that is by tendering before the court a certificate of the registration of that trademark. It's as simple as that. If you're claiming that a company is in existence, for example, the only way you can prove that this company is in existence is by tendering the certificate of incorporation of that company. So that also applies to trademark. If you're claiming, yes, I'm the owner of this trademark, I'm the owner of this sign, I'm the owner of this symbol, it symbolizes my identity or my brand, the only way you can prove that to the court is by tendering a certificate of registration to that effect. So that is where the issue of trademark comes in to register your trademark.
What about a trademark location? Does location matter in trademark? For instance, a name that has been trademarked somewhere in the U.S. and it's been used in Nigeria.
Yes.
Does the person who trademarked it in the U.S. stop the person in Nigeria from using it because he had trademarked it in the U.S.? I'll give you an instance. The name Wizkid.
Yeah.
There's an American artist, the name of The Weeknd, who at one time said he's the owner of that name, Starboy. So when Wizkid was called himself Starboy, The Weeknd came to say, that's the first, he's the owner of Starboy. He's been using Starboy. But that case did quite hold because I don't think there was a kind of a trademark. But I'm asking, in an instance like that, where someone in another country says, I own this name, I've trademarked it, for instance, does location limit trademark?
Yes, for trademark, location limits trademark. That's one of the shortfalls of trademark when compared to copyright. So I always advise people to instead you register your brand under the copyrights, provided that such brand can be registered as a copyright. Okay, like the issue of Wizkid. If you register Wizkid as a trademark, okay, now somebody else in the US can also use Wizkid, and Wizkid will not be able to sue that person for using Wizkid, even though he was the first person to register that name under the trademark as his brand. Okay, but if Wizkid had registered his name, Wizkid, under the copyrights law, okay, or under copyrights as the case may be, then nobody in the world can use that name, Wizkid, except for Wizkid.
So there's the difference between copyright and trademark.
Yes.
Is that copyright can be international.
Very well.
But trademark can
Yes,
be
it's
restricted by
yes,
location.
Yes.
Interesting.
Yes.
All right. How will you assess the level of disposition or respect to intellectual property rights in this part of this world? Largely, maybe because people are not well literate when it comes to the details of intellectual property. Why do you think you have that kind of, nonchalant attitude when it comes to respect for rights, when it comes to intellectual property? And what can be done to improve that literacy, especially on a day like this?
Of course, it has to do with sensitization, or the agency in charge of protection, registration, enforcement of these intellectual properties to always sensitize, the publics on the need, the importance to have your creative work trademarked, registered, so that somebody else cannot infringe on such rights. And when there's an infringement, of course, you have the right to approach the court for injunctive relief or for damages, as the case may be. So it is the duty of the agencies in charge of these intellectual properties to always sensitize, inform the publics, because a lot of us are not aware of the advantages that we can get from trademarking, from copywriting, registering our intellectual works. So even the artists, the musicians, they are not aware of all this, as much as they are even exposed. Even the filmmakers too, as much as they are even exposed, they are not aware of this. And even when they are aware, they just take this nonchalant attitude that, no, don't think anybody can use this, So, but there's a need for sensitization with respect to that. So the agencies in charge should do a whole lot of work to inform the public on trademark.
Aside from ignorance, maybe some persons may not be aware of the need for them to copyright or trademark some of the intellectual property. Is it a laborious process trying to trademark, copyright, or patent your work?
For trademark, I know much about trademark, the process involved in trademarking your brand, okay? Now, the first thing is if you want to trademark, let's say a mark as your brand, the first thing is for you to do a search to be sure that that mark has not been used by some other brand. So, and this search is usually conducted manually. There is no online search. So you have to approach the registry. And when we are talking about the registry, we are talking about the Commercial Law Department of the Ministry of Industry, Trade and Investment. Okay, so the patent and the trademark, patent and industrial designs registry, you have to approach them to do the manual search. So they do the manual search for you, and once they confirm that that sign which you want to trademark has not been used by some other brands, then they will give you the approval to go ahead and apply for the registration of that mark as your brand. So you're expected to file the application. So once you file the application to the registry, okay, so the next stage will be what we call examination. So the registry will have to examine your application to see that you have filed the application according to the rules and regulations with respect to filing application for registration of trademark. So once they have done that and they've approved that, okay, this application is well filed, then the next thing is publication. Now they publish your application to register the trademark via their journal. They have their journals. So they will publish it, and the essence of publishing is to allow for objections, to receive objections, oppositions. If there is any objection with respect to the registration of that trademark, within that time limit, I think 28 days or thereabouts, is for the receipt of objections with respect to the application for the registration of that trademark. So once there are no objections, the next thing is to issue a certificate of trademark with respect to that mark they have applied for trademark.
Okay. Now let's talk about the issue of infringement on intellectual property.
Yeah.
At what point will the law consider it to be like an infringement if someone uses an intellectual property? And then what are the penalties that are spelled out in the provision of the law against the issue of infringement?
Of course, when you say infringement, you have deprived the original owner of an intellectual property from using his intellectual property. You have either denied or you are also trying to you have either denied or you're one way or the other trying to deprive him from using it as well. Okay, so now infringement of intellectual property, of course, the remedy you have as the original owner of that intellectual property is a legal action. You approach the court, and in approaching the court, you can either claim damages or injunction, that is, stopping that person from using your intellectual property. So, and like I said, that the only way you can be able to convince the court that this intellectual property belongs to you is by tendering the certificate of registration of that intellectual property. So once you can do that successfully, then the court will grant your relief, either as damages, if you are claiming damages, or injunction, stopping that person from continuous infringement of your intellectual property rights.
What about seeking the consent of the original creator? Will it make any difference?
Oh, seeking the consent, yes. Like I always say, that intellectual property is usually transferable in the sense that you can license your intellectual property to a third party, okay, or you can assign your intellectual property to a third party. So yes, it's more or less like seeking the consent of the original owner before using same. So it is very much allowed.
But what are the risks involved in that if you are licensing a third party?
Now, of course, there are a lot of advantages to license. Now, the first one is it generates revenue. Let's talk about the advantages before we look at the risks now. Now, the advantages is that if you license your intellectual property, you can generate revenue from the licensee. You take money from him to license. Okay, that's one of the advantages of licensing your intellectual property. Now, another advantage is proper marketing. It enables marketing. Let's say, for example, if I don't want to mention a brand. Let's say a very popular brand in the US wants to come and sell that brand in Nigeria, okay? They don't know the Nigerian market. They don't know the local market here. So they can decide to license a Nigerian producer here to produce their product and sell. Because we in Nigeria, or the Nigerian producer here understands the market better than the foreign market. Okay, so the foreign person can decide to license his intellectual property to a Nigerian producer to use for proper marketing of that product in Nigeria. So that's one of the advantages. Okay, now, but the risk, there are also a lot of risk involved. Now, one of the risks is that you have intellectual property theft. In the sense that once you license your intellectual property, you don't really have a control of how the licensee uses that intellectual property, even though it belongs to you, because you've licensed it. So there can be an issue of intellectual property theft. Okay? Then also, you might not even get any revenue at the end of the day, if the licensee does not make money from your intellectual property. So that's another disadvantage or the risk involved in intellectual property. Then also, there is this issue of, how will I put it this way? I'll put it this way. There's this issue of dereping your reputation. Dereping your reputation in the sense that if you decide to license your intellectual property to a licensee who does not conduct business legally or ethically, and he's using your intellectual property to do that business, it affects your reputation as a person, be it a person or a company. So these are the risks involved in licensing, as much as there are also advantages in licensing intellectual properties.
So how has the internet, social media, and technology impacted intellectual property of people?
Yes, like I said, the technology, it's a little bit difficult to control the influx of technology, okay? You see people downloading music without the consent of the original owner of the music, or downloading literature works without the consent of the original owner of such literature work. This is area of technology. You can see that in that area, you're already infringing on the rights of that person because this thing belongs to that person. You shouldn't tamper with it without the consent of that person or without that person licensing it to you. So well, it is an issue that, we have not been able to solve it totally. We are just trying to manage it, okay? Most especially in Africa, in Nigeria, as the case may be, where we don't have a way to regulate the influx of technology. But over there, abroad, I think they are better structured, so they have a way of, limiting the influx of technology. I know in the music industry now, there's this Apple Music, Spotify, is a way of limiting the influx of technology into music, in the sense that it protects the rights of the real owners of this music or this creative content. They've licensed it to Apple. So if you want to have access to it, you can only go through Apple or go through Spotify. You understand? But in Nigeria, it's a little bit difficult because we are not at that level where we will not allow technology to infringe on or to cause an influx in infringement of the rights, intellectual property rights of the owners, such property rights.
Still looking at infringement of intellectual property, what would make it difficult for one to know if this work is owned or identify the owner of the work? And in case where there is dispute, what would make it impossible to prove ownership?
Like I always say, let me take copyright as one of those intellectual properties, copyrights. Of course, being the original creator of that creative, being the original producer of that creative entitles you over every other person of the copyright or the intellectual property rights with respect to that creative, okay? You being the originator of that creative entitles you automatically as the copyrights of that creative. But the issue now is, how do you prove that you are the originator of that creative work? That's where the issue comes. And the only way you can solve that issue is by showing a certificate of registration of that creative work as yours. So that's where the area of registration becomes paramount. So where there is a dispute, the only way you can prove is by tendering the certificate of registration of that creative work. Simplicity.
So for every creative work that you have, you should have registration or a license for it.
Yes.
Wow, that's a lot. So
Yes.
if you're an artist, for instance, or you're a writer, every lyrics you write, or every song for which you've written lyrics, every work you've done, you
Yes.
have to register,
You have to register,
all of them.
yes. If you have a music work, you register. You have a sound recording, you register. You have a film production, you register it. Okay? If you have a literature work, you register it. Under the Copyrights Act, there's a provision under the Copyrights Act that says that once you register a literature work, okay, you are entitled to the copyright of that literature work for 70 years after the death of the author of that work. So after 70 years, somebody else can. If you are the owner of a motion film, a motion picture, cinematography, let's say a film, for example, you have to register it. And once you register it, you are entitled to that copyright 50 years after the production of that movie, film, as the case may be. So after 50 years, somebody else can go and register and say it.
Have you seen instances like that? Maybe after 50 years, someone will now lay claim to that kind of intellectual properties. Is it that common?
It's not really that common, but I think there was one that was experienced in the US. I think 50 Cent had issues with something like that he said somebody took his music and all like that. So although I don't think the matter, and I don't think the matter was filed in courts, there was no litigation with respect to that. But that is the law in Nigeria. That is the law. But people are not aware. That's the law. If you are an owner of a novel, for example, and you register that novel as your copyright, you are entitled to 70 years of that copyright after the death of the owner of that work, is entitled to 70 years of copyrights. And don't forget that copyright also extends to your heirs. What I mean to your heirs, your inheritance. Even after death, your family will continue enjoying that copyright for 70 years after your death. So after 70 years, then that's the end.
All right. When it comes to intellectual property, people often talk about copyright, trademark, but less of trade secrets.
Yes.
So let's talk about it.
Trade secrets, like I said,
Yeah.
from the beginning of our program, I said trade secrets is one area of intellectual property that doesn't have an extant law protecting it. So, and that's the reason why people hardly enforce it when it is breached, because there is no extant law protecting trade secrets. That is the reason why when it is infringed on or it is breached, you hardly see people going to court, because there is no law that enforces it. There's no law that protects it. But I used to advise people that, okay, if you have a trade secret and you want to divulge, whoever you want to divulge such trade secrets to, you have to enter into a contract of confidentiality, non-compete, non-circumvention, in order to protect that trade secret. Believe me, a lot of products have their trade secrets that nobody knows about, that there's some products production that is peculiar to them. Okay, and the only way you can do that is to enter into a contract with a person who you want to divulge such trade secrets to. So once there is a breach, you can sue that person, even though there is no extant law protecting trade secrets.
Isn't there need for that law now that the reality is here and it's becoming something that people has to go by? People has to protect their trade secrets.
Yes, very correct. In other countries, they have a law, extant law, protecting trade secrets. It is only in Nigeria that I see that we don't have laws protecting trade. So it is time for the legislatures, with respect to this area of intellectual property, to come up with an extant law that will protect trade secrets as an intellectual property rights.
Sorry, in the absence of the law, what can a creator do to protect his or her trade secrets in the absence of the law?
Yes, like I said, in the absence of the law, the only way you can protect your trade secrets is in the absence of an extant law protecting trade secrets. The only way is to enter into a contract of non-confidentiality, a contract of non-compete, a contract of non-circumvention. So once it is breached, you just sue for breach of contract.
Breach of contract, okay.
And of course, you know that breach of contract as an area of law is regulated by the received English law. So you don't need any extant law to do that. Once there's an established breach, then you'll be entitled to whatever claim before the court.
All right, let's talk about shaping the future with intellectual property, shaping the future for creatives. For one of them, when we're talking about copywriting your work and even trademarking it, we'll discover that it's a laborious process for you to even check if the name has been used and how you go about it. What are the things that should be done to make it easy for intellectuals to protect their property as we shape the future on a day like this?
Okay, yeah, so the process involved in trademarking or registering your intellectual property rights should be less cumbersome. You know, like in the area of trying to register a trademark, where you have to go down to the registry to do a manual search. I think it's becoming outdated. There should be an online search engines for you to be able to search online. You don't necessarily need to approach the registry physically to search for whether or not the sign you want to trademark has been used already or it's still available. Just like the practice when it comes to registration of companies under CAC, there is an online search. You don't necessarily need to approach the physical office of the CAC to do a search. You can just simply search online to know if that company name is available or not. And even the registration is also done online. And even the certificate is issued online. You just have to download. I think if the trademark, patent, and design registry can adopt this process too, it will be a whole lot better compared to what we have now. People will not have to go through the stress, enormous stress of trying to register their signs or trademark, as the case may be.
Now, in the case of dispute, you approach the court, you are at the mercy of the court. But what are the rights you have as the creator of that intellectual property?
Okay, now, if as the creator of that intellectual property, the original owner of that intellectual property, the rights that you have once you approach the court is to tell the court to stop the person who is infringing your rights from infringing your rights. So you claim injunctive reliefs. Okay, aside from the injunctive reliefs, you can also claim damages against the person who has infringed on your intellectual property rights.
Who determines the level of the damage? At the mercy of the court, or you come up with what you feel?
Yes.
It's like an estimation of the damage that has been done.
Yes, of course. You know, there are various types of damages. Okay? Now, general damages, that is the damage that ordinarily flows from a breach. So at that level, it is the duty of the courts to determine what the general damage is, or what is the breach that originally flows from this breach. So what is the damage, or rather, that originally flows from this breach, okay? Literally flows from this breach. So it is for the court to determine that. Then if you have particular damage, then it is for you as the claimant to prove particular damages. Okay, this is what it has done to my business. You have to prove it to the court. So if you're able to prove that, then the court will grant the exact amount you are claiming as particular damage. But for the general damages, which flows naturally from a breach, it is for the court to determine.
The issue of a matter being status bar, does it apply to claim for damages when it comes to copyright infringement? For instance, you know that someone has infringed on your copyright,
yes,
and you did not take it up. You didn't file a suit against it. You wait for a number of years where the person has used it to make lots of money, and then you're suing the person and claiming damages for those number of years. At that time, what happens? Does the court say, oh, you knew at the beginning, you didn't say anything, or anytime you file, then the court takes it up for you?
Of course, you know, there are certain things that can stop you from, getting the judgment of the court, or from getting the audience of the court. And one of those things is the statute of limitation, where you bring a matter to court after the time which you are supposed to bring such matter. Of course, that robs the court of its jurisdiction to entertain such a matter. Now, in the case of an infringement of copyrights, the law that applies to contracts, statute of limitation, which talks about 6 years. Once there's a breach within the period of 6 years and you don't bring it to court, of course that matter becomes statute barred and the court will not be. I think it applies to, because this intellectual property comes under contract. So
let's talk about the issue of piracy.
Yes.
Whether we like it or not, it's still something to contend with in Africa. What can be done to discourage piracy? Pirating people's intellectual property, music, literal works, and things that has to do with the creatives.
Yes, of course, there must be sanctions for piracy. If you have been found guilty of piracy, you've pirated somebody's intellectual property, of course, there should be punishment for such a crime. Piracy is a crime. So there should be strict punishment for piracy.
What does the law say about the level of punishment and the magnitude of punishment? Is there perhaps this could also discourage people from doing it?
In Nigeria, looking at Nigeria, there's no established law as regards to the level of punishment for piracy. Even in our criminal code, there is no offense such as piracy. So that's where the issue comes in. So by the time we start seeing piracy as a criminal offense and it is incorporated into our criminal laws, of course, then there will be punishments for it. So we'll be able to know the established punishment for piracy. advanced countries, they have laws that discourages piracy. They see piracy as an offense, that if you found guilty, you'll be liable to strict punishment. So I think Nigeria as a country has to adopt that into our criminal law system, making piracy an offense and stating the punishment for piracy if you are caught.
What is the difference between piracy and intellectual property theft?
Piracy and intellectual property theft are one and the same, like twins. Yes, Siamese twins. You can't separate them, you know. So because if you pirate somebody's intellectual property, you have stolen that person's intellectual property. So it's the same thing.
All right. Now, if they are the same thing, if there is law against intellectual property theft because there is the intellectual property law that protects the work of the person, can that same law be used to tackle piracy?
You know, intellectual property theft, when you say there is a law against intellectual property, what does the Copyright Act, the trademark Act, you know, like I said, where there is a breach or there's an infringement of this intellectual property rights, you are only entitled to injunctions and damages. These are just contracts remedy or remedy. These are common law remedies. Okay, these are common law remedies. They are not punishments. They are not punishments. You know, if piracy is treated as an offense, once you are charged and you're found guilty of piracy, there's nothing like injunction or damages, which are just common law reliefs. What you will be liable to will be an imprisonment. You know, yes.
All right. Let's talk about patent rights now. What qualifies you to have the patency to an intellectual property?
Now, when you're talking about patent rights, you are talking about rights that are peculiar to creatives in the area of machines and computer gadgets. Okay? Now, if you have established a computer software, for example, of course, you will be entitled to patent rights. Or you've been able to establish, or you'll be able to produce a machine. It is peculiar to machines and computer gadgets. That's patent rights. Now, for you to be able to claim patent rights with respect to the development of a machine or a computer gadget, it has to be something that is novel. What I mean by novel, nobody has ever done something like that. It's something that is new. That is when you'll be entitled to patent of that machine gadget or the computer gadget which you have developed. You know, like in the area of software development, if you have been able to develop a software that is novel, that nobody has ever done before, a computer software, for example, that nobody has ever done before, that is novel, then you have right to patent to protect that novel creative.
All right, thank you very much, Victor Emeka Jibonoh, Esquire, who is Managing Partner and Head of Corporate Commercial and General Legal Services at Optics Legal Consulting, for talking to us today about intellectual property. So now you understand the difference between all of them: trademark, copyright, and patent. So you know which line you fall in when you need to ensure protection of your intellectual property. We thank you for being in the studio with us today.
It's always a pleasure to be here.
Early exchange, shaping policy, advancing development.